Hello and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And you know what? It's been a little while since we last talked about our good friends over at Epic who are currently suing Apple in order to break down the monopolistic walls that prevent Epic from selling their own stuff on the iPhone for whatever price they would like. If you are interested in that full story, going from that morning in August when Epic decided to just flout the rules of the Apple Game Store and put whatever they wanted up there, on through the lawsuit, the preliminary injunctions, and everything else, please do check out our playlist on Antitrust Epic. This video is actually not going to be about the legal specifics of that dispute. Instead, it's going to be about a story that I saw this morning that wasn't exactly what I expected. Here is a story from iMore.com that says, Apple says a new North Dakota bill could destroy the iPhone as we know it. Apple and Epic, brothers in hyperbole, no question. Staunch App Store critics like Tim Sweeney have lent their support to the move. Who can even believe it? And I'm not going to go very far into this article. We're going to talk about a lot of the specifics here, except to note that this Tim Sweeney tweet is just perfectly Tim Sweeney. I alone can protect you and make decisions for you is the timeless sales pitch for tyranny. Americans have always known better than to accept it as a governing principle. Now the pitch is being made frantically by tech corporations who surely know better. I tend to agree that that particular pitch, that I know what's best for you, is being made by tech corporations. Mr. Sweeney and I might disagree on which tech corporations are making that particular pitch, but we'll come back to that. In the Bismarck Tribune here, they say North Dakota Senate bill targets monopolistic app stores. Proponents of a North Dakota Senate bill say the legislation would clamp down on app stores seen as monopolistic, but opponents see it as interference and potentially harmful. The purpose of the bill is to level the playing field for app developers in North Dakota and protect customers from devastating monopolistic fees imposed by big tech companies, said Kyle Davidson, referring to a 30% fee imposed by Apple and Google on in-app purchases, which he said penalizes small app developers by raising prices and limiting choices for consumers. Where have we heard that before? I wonder. Now, The Verge picked up this story, entitled an article called New North Dakota Bill Would Force Apple to Allow Alternative App Stores and Payment Systems. They go over the bill a little bit. We're going to actually look at the specifics of the bill so we can talk about it. But they described it as a state bill. The proposed legislation would only affect the operation of businesses like the App Store within North Dakota, which isn't exactly how the internet or the App Store works, but we'll talk about that as well. But the sweeping changes the bill calls for would likely require companies like Apple to make substantial platform-level changes that could affect software distribution on a national scale. Or they just wouldn't sell into North Dakota, but we'll talk about that as well. Apple has already testified against North Dakota's new bill in a hearing on Tuesday with North Dakota's Senate Industry, Business, and Labor Committee. Apple's Eric Neuschwander, its chief privacy engineer, told the committee the bill threatens to destroy iPhone as you know it, and that it would undermine the privacy, security, safety, and performance that's built into iPhone by design. Simply put, we work hard to keep bad apps out of the App Store. The bill could require us to let them in. Basecamp co-founder David Heinemeier Hansen, who attended the hearing and testified in favor of the bill, criticized Apple for exaggerating the threat the bill poses to its business. And then The Verge reproduces a couple of tweets here, in which DHH says lol to Apple's statement. I know the Mac has been declared dead many times, but come on, to have Apple be the one chanting that nonsense is beyond over the top. North Dakota's SB 2333, the technical name for this bill we're talking about in this video, is the first real concrete legislative proposal I've seen that actually gives me hope that tech monopolies aren't going to rule the world forever. Fargo or Bismarck sound like wonderful places to set up shop under a shield against abuse. Now, you wouldn't need to, because the North Dakota law applies to the App Store in general, as long as it's selling 10 million into North Dakota, but we will, as I've said, talk about that as well. Hansen has since called for congressional action against Apple, as well as stronger antitrust regulation to try to force Apple to alter its policies. After the recitals, the 17 lines of SB 2333 read like music, written in a language I can understand without hiring counsel to parse it for me. Welcome to Virtual Legality. It almost seems too good to be true, but I sincerely hope that it is not. He wrote in his testimony, which he later released online, that you will listen to the small software developers from all over the country who are tired of being bullied and shaken down by a handful of big tech monopolists out of Seattle and Silicon Valley, who, as we've talked about in this series, are the ones responsible for building the marketplace in which you wish to enter. You don't have to love them. I don't love Apple. I don't love Android. I don't love Microsoft or Google. You don't have to love them to recognize that they actually built the thing that you are trying to sell your product onto, and that maybe they should get certain rights to protect the thing that they want to sell into the marketplace. Hansen says the U.S. needs a fair digital marketplace, free of monopoly abuse, and that no single change will have a greater impact than giving small software makers like us a choice when it comes to in-app payment systems and protection from retaliation if we refuse the onerous deal the monopolists are offering. Chairman Senator Jerry Klein said during the committee hearing that there's still some mulling to be done and that no action will be taken on the bill as of yet. In case you aren't familiar with this process here, this is not a federal piece of legislation. This is a North Dakota piece of legislation. It has been introduced for consideration by the body politic and will have to go through a number of processes, including the committee, and then a full vote of the Senate, probably another kind of view by, perhaps if they're bicameral, another chamber in their Congress, the governor, all sorts of stuff. This is many, many steps removed, but obviously Apple is concerned with it enough to have actually sent their people to go and tell the North Dakota committee here what a problem they think it would be if this law were to have been passed. Now, what does the law say that Apple thinks is such a significant problem? Well, here in Virtual Legality, we like to look at the specifics. So first, it starts out with some definitions. One, a developer, capital D, is a creator of a software application made available for download by a user through a digital application distribution platform or other digital distribution platform. Okay, note, we're not going to have a definition for other digital distribution platform. We've got a few definitional issues in this law. No big surprise if this isn't your first rodeo in Virtual Legality. Digital application distribution platform with maybe a capital digital, hard to say, means a digital distribution platform for applications and services provided to a user on quote-unquote general purpose hardware, including a mobile phone, smartphone, tablet, personal computer, and other general purpose devices connected to the internet. So, if you have been following this series, you know what they are likely trying to get at with just that definition. They're trying to aim this thing like a laser beam, primarily at phones and PCs and tablets, rather than video game systems. Because one of the things that has popped up in a lot of the discussion regarding Apple versus Epic is that there's no real good delineation point between Epic's theory against Apple under the Sherman Antitrust Act, which is a federal law that prevents antitrust and restraint of trade, monopolistic behavior in general at the federal level. There's no real way to separate Epic's theory against Apple's iPhone from a theory against Sony's PlayStation 5. So this, which isn't based on another law, this is obviously trying to propose a new law, is trying to split the difference and establish that they're concerned about general purpose hardware and not what we will see defined as special purpose platforms. The next definition is in-application payment system. It means an application, service, or user interface used to process a payment from a user to a developer for a software application, and digital and physical product distributed through a software application. Now, if you're familiar with how any of this stuff works, you can probably already spot the problem with this definition. They want to aim in-app payments at payments made from a user to a developer. But that isn't always the case and is easily tweaked on the back end. You can have the user pay Apple, you can have the user pay Google, have Google remit the payments over to the developer, and then suddenly you don't have an in-application payment system under this definition. Like I said, this maybe isn't the best thought through law. It is designed to be simple, which is laudable, but it also creates holes in the thought process that we're looking at here. Now, here's that exception. Special purpose digital application distribution platform means a digital distribution platform for single or specialized categories of applications, software, and services provided to a user on special purpose hardware, including a gaming console, music player, and other special purpose devices connected to the internet. Now, you could probably already spot the issue with this particular definition, and that is if you go and you turn on your Xbox Series X, congratulations on getting one, by the way, you can put your microphone in your controller, you can call up a friend, you can call up 5 friends, you can talk in a party, you can play that Spotify playlist, you can browse the internet, and you can watch your Netflix movies. So the delineation between a special purpose platform and a general purpose piece of hardware is perhaps not great. Doesn't make the law invalid. It doesn't. Unlike the Sherman Antitrust Act things that we've discussed in the past, this isn't trying to interpret an already existing law. Politicians around the globe are permitted to write the laws as sillily as they like. And so if there is this definition here that just says a gaming console is special purpose digital application distribution platform, well, then it is. And the right way to argue about it is through politics and lobbying and discussions with your congressman if you're in North Dakota. But let's see what the actual rule does. A proprietor of a digital application distribution platform. So again, that's the definition here for general purpose hardware. So we're just going to say a proprietor of a phone. Let's call him Apple, just cuz. For which cumulative gross receipts from sales on the digital application distribution platform to residents of this state exceed $10 million in the previous or current calendar year may not. So what does that say in non-legalese? It says Apple, as the makers of the iPhone, if they receive more than $10 million through their digital application distribution platform, their sales on the phone, of more than $10 million in North Dakota, they may not do these things. And they may not do these things generally. It doesn't just apply to sales or interactions that they would have with North Dakota. This will apply to the entirety of the Apple iPhone platform, which is one of the reasons why you have Apple coming in and testifying to a North Dakota committee at 10:30 on a Tuesday morning, is because this would have a negative ramification for their entire operating system. Unless, of course, they flip the switch that says no North Dakota sales. Now, what can't they do? Well, they can't require a developer to use a digital application distribution platform, the phone itself. Remember, that's the definition they use for the general hardware. So you can't require Epic. Let's just use Epic as kind of a name just out of my head. You can't require Epic to sell their stuff only on your phone or a digital transaction platform. That's an interesting turn of phrase. They didn't actually define digital transaction platform. Maybe it got left on the cutting room floor. Probably a definition that would be added in amendments to the bill as it got considered by the committee as the exclusive mode of distributing a digital product. So you're Apple, you've got the iPhone. This prohibits you, if you get more than $10 million from North Dakota residents, from prohibiting Epic from selling their own stuff away from your phone or only through your app store. Pretty sure digital transaction platform is going to equate to app store when all is said and done here. Would have been nice to get a definition. The other thing you can't do, you can't require a developer to use an in-application payment system as the exclusive mode of accepting payment from a user to download a software application or purchase a digital or physical product through a software application. So you can't do those in-app purchases. That's what you're trying to hit if you're the Senate in North Dakota with this particular rule. Of course, that wide hole in the definition that you used for in-application payment system that requires a payment from a user to a developer allows Apple to, if it wanted to, offer user to developer or user to Apple at its discretion. And now suddenly it's not the exclusive mode of accepting payment from a user because you can instead pay Apple. So wouldn't really prohibit them from doing that either. The final thing you can't do is you can't make trouble for Epic when it tries to make trouble for you. You can't retaliate against a developer for choosing to use an alternative application store or in-application payment system. Now, you're not required to allow them to use those things. We've got references to exclusivity here, but you could have other things that Apple would otherwise provide and give them access, as we just talked about with respect to in-application payment systems. But if they decide to use something on their own, you can't quote-unquote retaliate against them with no definition given. An agreement that violates this section is unenforceable and is deemed a violation of this section. In other words, the App Store guidelines right now that says you can sell your stuff through the App Store, you can't sell it on your own site unless you also sell it through the App Store, all these various rules that we've talked about in this series, those would be void on their face. The contract that you entered into, that you signed your name to, North Dakota would declare it void. This section does not apply to a proprietor of a special purpose digital application distribution platform. Just so we're clear, even though the logic isn't there, there's no real reason to delineate between the monopolistic 30% fees charged by Apple and the non-monopolistic 30% fees charged by Microsoft and Sony, we're still going to do that because, hey, maybe the senator watches Virtual Legality, and Hoeg pointed out that that's a problem for a whole mess of things that are out there in the world that, yes, might be specialized. Those medical devices or other things that aren't designed to just get you on the internet. But regardless of the logic, we can do it because we're making the laws. And in North Dakota, we just say, no, video game consoles are out. Okay. The Attorney General shall receive complaints and investigate violations of this section and may bring an action in any court of competent jurisdiction to obtain the legal or equitable relief on behalf of an individual aggrieved by the violation. So it looks like North Dakota is giving Epic what they want, or is at least considering it. This law does what it says on the tin. It says, hey, if we get the definitions right, and I'm reading this and being a little bit cruel to the legislature, oftentimes when you have a bill initially proposed, it does have these kinds of holes and ambiguities. I would love to be able to tell you that the legislatures around the country or the federal legislature just gets these things right off the bat. They don't. In fact, the ones that actually get executed as laws aren't right and often have little references in the federal code that says, we think Congress meant this subsection, so we're going to interpret it that way. It just is what it is. But this law says, hey, you are not going to be allowed to make your app store exclusive. You're not going to be allowed to make your in-app payment system exclusive. And if you try to do anything to Epic for doing something else that you don't want them to do, that's going to be a violation as well. And the contract you try to do to enforce these things that are now illegal is going to be void on its face as a violation of this section. That's exactly what Tim Sweeney wants, which is why Tim Sweeney is celebrating on Twitter. However, he's celebrating in a fairly weird way. I alone can protect you and make decisions for you is the timeless sales pitch for tyranny. This is coming from a person that is in charge of a multi-billion-dollar enterprise that says to whatever Americans might be out there that like a walled garden, that prefer an Apple approach, that like an app store that doesn't have to deal with other stuff. And I know a number of you are going to come to my comments and say those people don't exist. I'm telling you that they do. And say, no, Tim Sweeney of Epic Games, know better for you. And not only do I know better for you, I'm going to back up a government edict that prohibits the behavior that I don't like. And then while I back up that government edict to prohibit that behavior, I'm also going to pontificate on how I'm helping you avoid people that tell you that they can protect you by making decisions for you. It is quite the hypocritical curveball, and I love Mr. Sweeney. He's great on my Twitter. He does this on a regular basis, and I do not begrudge him or his company the ability to go and lobby for changes like this. Epic will be benefited by opening the doors to the walled garden. The other people you saw referenced in the Verge article, these people that want to sell their things on the Apple iPhone and pay less than 30% to potentially get access to more people and do whatever they want, regardless of Apple's rules, they will all benefit. I do not begrudge them seeking out government intervention, but I can talk to you all here in Virtual Legality about how the stance itself is self-aggrandizing, self-interested, and not even close to what Tim Sweeney portrays it as here. Now, I do want to say a couple of things about this law. One of the reasons you don't see kind of antitrust-aimed laws at the state level in the United States so much is because you've got problems with the overall civics kind of construction in the United States. Remember, if you will, in Article 1 of the U.S. Constitution, Congress, the federal Congress, has the power to regulate commerce among the several states. Interstate commerce is what we generally call it in constitutional jurisprudence, which means that Congress is the only one with that power, and the law looks down pretty heavily on states that try to burden interstate commerce in a way that the Congress itself, at the federal level, hasn't done. Now, we've talked at length here in Virtual Legality about problems with the modern Commerce Clause jurisprudence, that the Congress at the federal level has enormous power over every single aspect of everybody's lives because of various court decisions, especially in the past 150 years or so. But what that means is that Congress, by enacting the Sherman Antitrust Act, by doing certain things with respect to potentially regulating Apple and Google, and potentially not doing so, you run into a problem if you are a legislature in, say, North Dakota or South Dakota or Oregon or anywhere else, with the concept that the federal government is the one in charge of the interstate commerce concept. And that runs into something that we call the Dormant Commerce Clause. The Dormant Commerce Clause here, is described by Cornell, refers to the prohibition implicit in the Commerce Clause against states passing legislation that discriminates against or, and here's where it would be important here, excessively burdens interstate commerce. It's an easy Dormant Commerce Clause case if North Dakota had tried to pass, well, you can charge everybody else 30%, but you'll charge North Dakota less, or do something else to benefit specifically North Dakota and harm the other states. This doesn't do that, but it does burden interstate commerce. Why? Because the internet in and of itself is interstate commerce. That money that you're trying to use to buy V-Bucks on Fortnite is going to North Carolina, is going to somewhere else that's going to process that data, that's going to process that monetary payment, and then zoom all the way back around the world back to you. Using your iPhone, paying for something on your iPhone is interstate commerce by its very nature. So one state in the country doing something that would impact the entirety of the Apple iPhone and Google Android ecosystem, as well as it looked like the PC and tablets and a whole bunch of other things, potentially means that every other state in the country, in the United States, and yes, truthfully, every other country in the world, has an interest in what this state is doing. And in the federal structure of government, we don't want the United States economy dictated by the Senate in North Dakota. You might want it. You might love this law. I don't know. Leave a comment to this video. But there are going to be problems that the epics of the world run up against, even if they're trying to keep you from tyranny, apparently. And that's even without saying what I mentioned earlier in this video, which is that at the end of the day, one of the things that Apple can 100% do is say, all right, well, we're not going to sell into North Dakota anymore. And North Dakota is not driving our profitability. And maybe you'll change your mind when North Dakota can't get Google Androids, can't get Apple iPhones, and, there you are. So it's one of those areas where Apple has a certain amount of control. North Dakota can do what it likes. Apple can sue them. Apple can make all these changes. I do think it's a little bit hyperbolic. I think the people commenting on the Verge article and the Verge quotes here are correct to point out that some of the commentary about Apple saying, oh, the entire iPhone will change is hyperbolic. Corporations, especially Apple, have a long history of being flexible in the face of government edicts and regulations, but some of that flexibility is simply flipping the switch and deciding, hey, we're not going to sell X into jurisdiction Y. And you've seen that in certain places like Australia and elsewhere where Apple has said, all right, well, we'll turn it off, and then you can come back to us when you're interested in our product. We understand you want to do what you want to do with your constituents, but we don't have to sell it to you if that's what you elect to do. So there's a long way to go here. Certainly, I love talking about these topics. If you like these conversations, this has been Virtual Legality for today. We talk about business and law of pop culture, technology, video games, and everything in between very, very often. Please consider supporting us. We have some links in the video where you can check out some ways to support the channel. Or if you don't want to put your dollars down, I can't blame you at all. If you like this, just subscribe. Tell your friends. We appreciate every little bit that helps, every little bit of growth that we have in this channel. And hey, we love talking about this stuff. Hopefully you love hearing about it. Thank you so much for joining us. If you caught it on YouTube, thank you so much for listening. And if you listen to it as a podcast, thank you so much for listening. I will catch you on the very next episode of Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.